Tonight's webinar is by Miller Thomson. Miller Thomson is one of Canada's most respected law firms with close to 550 professionals practicing in 12 offices across the country, including Toronto, Markham, Vaughan, Kitchener-Waterloo, Guelph, London, Vancouver, Calgary, Edmonton, Saskatoon, Regina, and Montreal. We go beyond a strict technical analysis of the law. In providing advice, we take a practical approach that combines legal knowledge and analysis with risk management, quality of care, and resource considerations. Our team-based practice ensures that issues are addressed at the appropriate stage and form part of our risk-managed approach to legal services. Miller Thomson's Health Industry Group is one of the firm's key industry-focused teams. We have a consistent track record in providing practical, creative, and cost-effective advice, combined with an unyielding service commitment to our clients and the communities in which we practice. Our speakers tonight are Lauren Parrish and Lisa Spiegel. Lauren Parrish is a lawyer at Miller Thomson LLP. She has a broad advocacy practice focusing on litigation for private and public health industry clients before Ontario's courts and administrative tribunals, including the Health Professions Appeal and Review Board. She specializes in professional negligence and professional disciplinary matters and has extensive experience advising regulated health professionals on their professional obligations, as well as assisting in responding to complaints before regulatory colleges. Lisa Spiegel is the advocacy lead in Miller Thomson's Toronto Health Industry Group. Lisa's practice includes acting on behalf of various regulated health professionals, including before boards, tribunals, and all levels of court. She routinely conducts educational training for health institution clients and for professional regulatory associations. Lisa's background includes her role as senior prosecutor at the College of Physicians and Surgeons of Ontario. In this position, Legal provided regular advice to College Counsel and the college's various statutory committees, as well as drafted bylaws and regulations and provided advice on college policies. As a prosecutor, she conducted complex hearings relating to allegations of incompetence, professional misconduct, and sexual abuse. Welcome, Lauren and Lisa.
Thank you very much, Cheryl. As you just stated, I'm Lauren Parrish. I'm presenting with my colleague Lisa Spiegel tonight, and we're going to be discussing the issues involved in investigations and complaints before your regulatory college. There's a number of questions that we're going to address in this presentation, and they're set out on the slide as well as the slide following. We're going to talk about the role of the college, what governs college investigations, what triggers a college investigation. We're going to go into detail about what actually is professional misconduct, incompetence, and incapacity. We're going to discuss the powers of investigators in a college investigation, the process for investigating a complaint, and we're going to answer the question of, can the college interfere with your practice during an investigation? We're going to go on to discuss what the college can do after an investigation is completed, whether the results of an investigation are public, whether a disposition from your college can be reviewed further by the courts in Ontario, and then we're going to discuss strategies for proactive risk management with respect to dealing with investigations and complaints. And we're going to touch on, of course, COVID-19 and any new considerations arising out of the current situation.
Thanks, Lauren. This is Lisa Spiegel, and thanks everyone for joining this evening. You might be wondering why you need to hear a presentation on complaints and investigations. You may be someone who's practiced for several years and has never received a complaint, or you might be new to the profession, very confident in your skill set and have no plans to break any rules. The truth is, the vast majority of you will never receive a complaint or be the subject of a college investigation. So why are we speaking about this today? Because the other fact is, you never know if you'll be the subject of a complaint or a college investigation. And those that have also didn't expect to be the subject of a complaint or a college investigation. Every optometrist that I've acted for in respect to complaints, and there have been several, Even those who are extremely confident in their position in respect to the complaint and their ability to respond effectively has found the process of a college investigation extremely daunting. It's our hope that by becoming familiar with the process and understanding the system well, it can help mitigate against the risks of a complaint. So you'll practice more defensively than you might already be doing, or remind you to practice defensively. And it will give you some helpful knowledge if you ever become the subject of a complaint, and therefore hopefully mitigate against the stress involved. At the end of the day, no one is immune from the possibility of being the subject of a complaint. It's effectively an occupational hazard for professionals who are self-regulated. That includes, lawyers, accountants, and all regulated health professionals. We do hope this presentation will remind you to take care in how you practice. And we also hope that you'll never have to use the information that you hear this evening, but are arming you in case you do.
Your college creates an annual report each year, which is published on the college's website. This report gives some interesting statistics with respect to complaints and investigations. The 2019 report is not yet published, but we have gathered some statistics from the 2017 and 2018 reports that we've sprinkled throughout this presentation to give some context to the content you're going to hear. As you can see on the screen, we break down the number of complaints that took place in 2017. So there are roughly 2,400 optometrists registered with the Ontario College of Optometrists. In 2017, the college received 57 complaints. It initiated 12 registrar's reports, which we'll discuss in more detail later in the presentation. It held 4 discipline hearings, and it referred 3 additional matters to the discipline committee. And for better or worse, these numbers increased in 2018.
But for context, so did the number of registrants at the college. So the college's mandate, according to the college's website, is to serve the public by regulating Ontario's optometrists. It states that the college uses its authority to guide the profession in the delivery of safe, ethical, progressive, and quality eye care at the highest standards. The mandate, the role of the college is also set out in terms of what the duties and objects of the college are. And they're set out in legislation that I'll be speaking to in some detail as we go forward. And that legislation notes that the duty of the college is to serve and protect the public interest. And among the many objects of the college are to regulate the practice of the profession and govern its members, to maintain the standards of qualification for persons to be issued a certificate of registration, and to maintain standards of practice to assure the quality of the practice of the profession. So ultimately, as you've heard, the mandate of regulated health professional colleges is to protect the public. And while the college is certainly there to guide its members, their duty is to the public. In fact, one of the key penalty principles argued at discipline proceedings is ensuring that the public maintains its confidence in the college's ability to protect the public. This is an essential component to the notion and principles behind self-regulation. Your peers, your optometry peers, set policy, they set guidelines, they grant you with certificates of registration, and they have the power to suspend or remove certificates of registration or put conditions on certificates of registration. Self-regulation suggests that peers are best suited to these roles. However, in carrying out their roles, protection of the public is at the forefront. And when it's not at the forefront, the ability to self-regulate, which is in fact considered a privilege, is questioned. And we've seen in various jurisdictions where governments have become involved, where the public interest mandate is just not at the forefront of the college's activities. So what governs colleges' investigations? The Regulated Health Professions Act and its various regulations is the legislation that governs all 26 regulated health professionals. Schedule 1 to this act lists the various professions. Schedule 2 is the Health Professions Procedural Code. And this code is what I'll be referring to it, sets out not only expectations of members, but also college processes for registration of its members and for the quality assurance committees of each college, for complaints and other investigations, and for discipline and fitness to practice hearings. We're not addressing in this presentation fitness to practice hearings, but we will touch on what may trigger such a proceeding, which is issues of incapacity. The code also addresses one's duties to report, which Lauren will address in the coming slides. And the other important piece of legislation and regulations that you ought to be made aware of is the Optometry Act. Each regulated health professional is governed by the Regulated Health Professions Act and profession-specific acts. So what triggers college investigations? Throughout this presentation, we'll be referring to various provisions in the code, starting with what triggers a college investigation. The college can begin an investigation anytime it's in possession of knowledge about a member that gives rise to issues of concern, and if the registrar has reasonable and probable grounds to believe a member has committed an act of professional misconduct or is incompetent, she may ask the Inquiries, Complaints, and Reports Committee to appoint investigators to conduct an investigation. Now, the information that can go to the registrar can come from, well, unlimited sources, but examples are through mandatory reports, colleagues making reports to the college that are not necessarily mandatory but permissive. It could come from a police report, and it could come from an insurance company responsible for health benefits. There's a variety of ways information can land in the college's plate, and it will be moved to the registrar's desk, and she will determine whether there's reasonable and probable grounds to believe a member has committed an act of professional misconduct or is incompetent. Now, that test is a legal test. There's a subjective and objective component to it, and in fact, it's been the subject of debate and challenge at times when an argument may be made that whatever information has launched this investigation ought not to really have formed reasonable and probable grounds. But anyway, that is one route to an investigation. Another route to an investigation may be information coming to the Inquiries, Complaints, and Reports Committee, I'm going to call it the ICRC, from the Quality Assurance Committee. Quality Assurance Committee, as you may know, conducts things like peer reviews. Their information is in a lockbox. It's meant to be remedial, not to be punitive, but there are exceptions to this lockbox principle where they can't use any information. And those exceptions are if they think that an act of professional misconduct may have occurred, in which case they can provide limited information to the ICRC to launch an investigation, and that includes the name of the member and the nature of the allegations. And beyond that, they can't say why they have this feeling that there may be professional misconduct. It's quite a cryptic process, actually, and the ICRC takes that information and starts an investigation upon hearing from the Quality Assurance Committee. It doesn't happen too often, but it can. The most common route to an investigation is through a complaint. Now, the complaint is not defined. What a complaint is not defined in the legislation, but it must be in writing, and it typically is information that the college receives from a patient or a patient's family member, and that is the vast majority of routes to an investigation, through a complaint.
As regulated health professionals, you have a duty under the Health Professions Procedural Code, which we're referring to as the code, to self-report certain information to the college in specific circumstances. You must advise the college in writing if you have been charged with or found guilty of an offense. This includes criminal and regulatory offenses. And your report must include information on the nature of the offense, including a description, the date you were charged with or found guilty of the offense, and the name and location of the court that charged you or found you guilty of the offense. With respect to a charge, you must advise the college of any bail conditions or other restrictions. In addition, you must report if there has been a finding of professional negligence or malpractice made against you in Ontario or elsewhere. So this generally relates to a civil lawsuit where a court has found that you fell below the requisite standard of care, and those types of decisions where you have been found liable need to be reported to the college. You also have a professional duty to report other members of your profession and of other regulated health professions to their respective colleges in specific circumstances. And this isn't something that anybody ever wants to do, but it is an obligation on you. This comes from section 85 of the code. 85.1 states that you must file a report with the college if you have reasonable grounds which were obtained in the course of practicing optometry to believe that another regulated health professional has sexually abused a patient. We're going to expand on what constitutes sexual abuse later in the presentation because there have been a number of changes in recent years with respect to sexual abuse and certainly a tightening of the restrictions around this, and the college is taking this type of conduct very, very seriously. But it's important to note that this obligation to report sexual abuse is not just with respect to other optometrists. You have a duty to report to the relevant college of any regulated health professional who you believe to have sexually abused a patient. So this applies to all 26 of the regulated health professions in Ontario. In addition, section 85.2 of the code states that persons who operate, quote, a facility where one or more members practice shall file a report with the college if the person has reasonable grounds to believe that a member who practices at that facility is incompetent, incapacitated, or has sexually abused a patient. So this is an even broader obligation. It also includes a duty to report incapacity and incompetence, which again, we will expand on exactly what that is later in the presentation. But I would note that health facility, the term health facility, is not defined, and it should be interpreted broadly to include any place where optometry is practiced. So if you own and operate an optometry or a multidisciplinary clinic, you have this duty to report a regulated health professional who practices from the facility, from the clinic, if you have reasonable grounds to believe that the professional is incompetent, incapacitated, or has sexually abused a patient. The reporting obligations continue, and they're actually further expanded in section 85.5, which sets out reporting obligations for employers and business affiliates. This section states that a person who terminates the employment of a member, meaning a regulated health professional, or who dissolves a partnership, a health professional corporation, or an association with a member for reasons of professional misconduct, incompetence, or capacity, must file a written report with the registrar within 30 days, setting out the reasons. So this section goes even further, and it actually states that where a member resigns, the member's employer or business partner still has a duty to report to the college if they have reasonable grounds to believe that the resignation resulted from professional misconduct, incompetence, or incapacity, or where the resignation took place in the middle of an investigation into professional misconduct, incompetence, or incapacity. So these are wide-ranging reporting obligations, and they apply to optometrists who employ or in a partnership or a business association with another regulated health professional. Members can be fined if they fail to make these types of reports, or could potentially have consequences themselves before their college. And when in doubt, they're tricky issues and people, understandably unpleasant to deal with. Always contact legal counsel to assist in determining if there's a duty to report and what should be included in that report if you're ever in doubt. I do note that the code does offer protection for persons who are forced to make a mandatory report with respect to another health professional. The code specifically states that no action or proceeding shall be instituted against a person for filing this type of report in good faith. This means it's meant to offer protection to persons who make a report if they do so in good faith, meaning they're not doing so with a malicious intent to try to cause harm to another professional. And that protection is offered so that people are not deterred from making these reports. And this provision means that a member cannot become the subject of a college complaint or cannot be sued as a result of making a report about another health professional in good faith. A common question is, does the college have discretion not to investigate a certain complaint? And the answer to that question is no. The college must investigate all complaints. That's part of their mandate. However, the process can be truncated in certain situations. If the Inquiries, Complaints, and Reports Committee considers a complaint to be frivolous, vexatious, made in bad faith, moot, or otherwise an abuse of process, It can truncate the process by giving notice to the complainant and to the member that it intends to take no further action. For example, a common example that we use of a frivolous complaint would be a complaint where the patient complains that they don't like the wall color at the clinic. That's a frivolous complaint, and where the ICRC issues the type of notice that I've just described, both parties have a right to make written submissions on the issue, but ultimately the ICRC can decide to take no further action at an early stage. In addition, a more recent development with your college has been the use of alternative dispute resolution to resolve certain complaints early on. The college registrar can refer a complaint for ADR, alternative dispute resolution. Generally, this referral is made for complaints that are considered to be less serious in nature. For example, a complaint that's strictly to do with communications issues. The college's annual report indicates that 5 complaints were referred to ADR in 2018. Where a complaint is referred for ADR, the college will appoint a third party to act as a mediator. The mediator will speak with both the complainant and the member individually. And in our experience, these conversations have happened by phone. The mediator will try to understand the issues for the complainant and will essentially try to find a way to resolve the issues between the parties early on. Settlement terms arising out of a mediation can include anything that the parties are willing to agree to. It could be the member providing a letter of apology, agreeing to update a clinic policy, to undertake certain educational endeavors, or to engage in staff training. It's really open to whatever the member is willing to agree to and whatever the complainant will accept. If a settlement is agreed to, it is recorded in a written settlement agreement that is signed by both parties. This settlement agreement must be approved by the ICRC before it's final. It's not enough that the parties have just signed it. The ICRC actually has to review it and approve it. If the settlement is approved, the complaint is considered to be withdrawn. And your college's annual report indicates that 2 of the 5 complaints that went to ADR were withdrawn in 2018. So some mixed success with this approach. We have been involved in the ADR process with your college and found that it can be effective. And it's important to note that the entire mediation process is confidential. This means that all information gathered in conversation with the mediator, all settlement agreements, any additional documents that may arise, for example, a letter of apology, must be kept strictly confidential by both parties. And if the matter cannot be resolved through mediation, then the complaint goes through the usual investigation, response, and decision process, which we'll expand on later.
I just want to add that not all, and perhaps Lauren touched on this briefly, but not all complaints will lend themselves to the college suggesting ADR. It's got to be something that they think is resolvable and not highly contentious, I would say. How long does an investigation take? I mean, we set out the legislative requirements on this screen. They're supposed to complete an investigation within 150 days. If there's a delay of more than 210 days, they're supposed to give notice. The bottom line is it's often not, they often do not meet their statutory requirements. I would say that's the truth with most colleges. They offer extensions when complainants need longer time. They are happy to give extensions if registrants need more time in certain circumstances, like just retaining legal counsel the day before your response is due, which don't ever do that, call legal much earlier. But in those circumstances, they would certainly grant an extension, and often for various reasons, staffing and other related issues, they just don't get it done in the time that they're supposed to. And again, it's not unusual to your college by any stretch. And I'm sure they do their best. But at the end of the day, it can be a stressful process. And at some point, you just have to know that it will come to an end. And it comes to an end a lot earlier than anything close to what civil litigation looks like. So, you know, we try to push things along as quickly as possible. Professional misconduct. So what does it mean? First of all, the code governs all health professionals, as I've mentioned earlier, and sets out provisions applicable to every type of regulated health professional. And then there are certain acts of professional misconduct that are specific to the specific profession. So what's applicable to all regulated health professionals are the following. First of all, sexual abuse of a patient applies to everybody. That's professional misconduct. If you're found guilty of an offense that's relevant to your suitability to practice, that is also applicable to every regulated health professional. What is relevant to one's suitability to practice, I guess, is case-by-case analysis, but there's broad discretion to find really most acts of criminal acts relevant to members' suitability to practice on the professionalism, looking at it from a professionalism lens. And also, if one is found guilty of professional misconduct by a regulatory body outside of Ontario, and the same acts would be considered professional misconduct in Ontario, that's going to be professional misconduct. Then there's the provision that applies saying whatever your regulations say is professional misconduct. And here's where we turn to the Optometry Act, which Lauren's just switched the slide. Thank you. So the Optometry Act has a general regulation. First of all, the Optometry Act is very, very small. It doesn't say a lot. It talks about your scope of practice and whatever controlled acts you can perform. It's otherwise quite a thin piece of legislation, but accompanied with it is what's called the general regulation. And in it, it sets out, I think there's 39 acts of professional misconduct that they specify. And so we've listed quality of care, so failing to maintain the standard of practice of the profession, a misrepresentation about your qualifications, poor record keeping, which I would say is failing to maintain the standard of practice, excessive fees or billing issues. We've seen some of that. And certainly you have insurance that are live to those issues. Patient abuse, contravening the Optometry Act, which again talks about what controlled acts you can perform or what your scope is, or contravening the Regulated Health Professions Act. And then there's the broad term, which can mean whatever your peers at the college determine it fairly means, which is engaging in conduct or performing an act that, having regard to all the circumstances, would reasonably be regarded by members as disgraceful, dishonorable, unprofessional, or unethical. And that really is a broad sort of catch-all act of professional misconduct, and it tends to be behavioral related. So, you know, I sort of see things as clinical conduct, billing issues, or behavior related issues. Those are sort of the three main areas. So how does one determine what the standard of practice is? First of all, standards of practice are set out in the OPR, which is set in your, there's a link to it in the college's website. You ought to, I'm sure you are all familiar with it, and it covers areas of general clinical matters, documentation, general procedures, as well as specific diseases, disorders, and procedures. If you aren't familiar with it, or if you have questions about what your college says about certain things, it's a very useful guide. Not all colleges have such a specific guide. But not all standards of practice are set out in writing, either in the OPR or elsewhere. So how does one determine? We just can't cover every clinical scenario. So it's not unusual that standards are just not in writing. So how does one evaluate what a standard of practice is? Usually it's done by an expert. I mean, it's probably invariably done by an expert. And there's often competing experts who will have competing opinions, but what's usually found to be the standard of practice is what's taught, what's done, and what's in writing. So again, you know, we learned this in school, this is the general practice of my peers, or this is in fact in writing in some, you know, journal applicable to your profession, if not, of course, the OPR.
Incompetence is another term that we've raised, and another question that arises then is, what is incompetence? It's actually defined in the code under section 52, and that states that a member is considered incompetent if the member's professional care of a patient displayed a lack of knowledge, skill, or judgment of a nature or to an extent that demonstrates that the member is unfit to continue to practice, or that the member's practice should be restricted. So incompetence relates to practicing and practicing below the standard of care, which is different than incapacity. This is also defined in the legislation in section 1, which states that a member is considered incapacitated if the member is suffering from a physical or mental condition or disorder that makes it desirable in the interest of the public that the member's certificate of registration be subject to terms, conditions, or limitations, or that the member no longer be permitted to practice. It's important.
Can I go on for 1 second on that? That's
Yep.
not an act of professional misconduct. It's a separate category altogether. I mentioned early on about fitness to practice proceedings. That's where that plays a role. So just for context.
Thank you, Lisa. And it's important to note, it's really important to note that just the fact that someone is suffering from a physical or mental condition does not mean that they're incapacitated. There really has to be the nexus where that physical or mental condition is affecting their ability to safely practice. So you can see on the screen from your college's annual report, there's a breakdown of the nature of allegations in various complaints. And as you can see, the largest number of complaints relates to behavior or communication that is perceived to be unprofessional. The next largest category is described somewhat vaguely by your college as complaints that relate to a breach of the Regulated Health Professions Act, the code, the various regulations or standards of practice. And then we see a number of complaints relating to improper fees or billing. We have glasses and contact prescriptions, generally quality of care. There's complaints about staff supervision, failure to diagnose or misdiagnosis, improper delegation and conflict of interest, amongst others. So it's a fairly widespread, and it covers a number of the areas of professional misconduct that Lisa has highlighted. And we'll touch on later in the presentation strategies for risk management with respect to complaints and how you can adopt some best practices to try to avoid even becoming the subject of a complaint.
But I would just, before we get to this poll, actually, why don't we do this poll and I'll speak to the issue of unprofessional behavior as we do. So the poll is, can the college enter your place of practice and require you to provide them with a patient record? So we want to take a second and answer that. And while we do, I just, as you noted in the screen previous, which we won't need to turn back to, the behavior-related issues was the #1 type of allegation, and it's really important to be mindful of that. People are expecting professionalism, and your college requires professionalism, and that doesn't just apply to you, it applies to your staff as well, who you're responsible for. So I think it's just, those numbers are instructive in looking at the nature of the complaints. Doesn't mean all of those things are valid, but that's where people are complaining the most, is issues of professionalism. So just gonna look to see. Okay, so 80% of you answered yes, the college can enter your place of practice and require you to provide them with a patient record, and 20% of you voted no. So the answer is yes, but it's not unqualified. So if you can just turn to the next slide, we're going to close the poll. An investigator can only enter your place of practice and obtain records from you if there is an appointment of investigators, or if there's a complaint and the complaint gave consent for the college to obtain his or her record only. Complainant doesn't have the ability to consent to the college obtaining any other records aside from their own, for obvious reasons. So the only way that the college can come in and have the power to obtain information from you when they walk into your office is if they have what's called an appointment of investigator. Early on in this presentation, I talked about the various ways an investigation can be launched, through a complaint, through a registrar's investigation, and through the Quality Assurance Committee. If the college wants to come and get documents, they have to appoint an investigator, and once they do, that investigator has a number of very wide-ranging powers, one of which is to inquire into and examine the practice of a member, ask to get a summons to require people to provide statements and take documents from people's offices that are relevant to the investigation. So I do want to just give a little bit of warning. Your college is going to be following the rules. That said, hopefully you'll never get a knock on the door from the college seeking to take documents from your office, but if you do, you all ought to have access to the on-call program that Miller-Thomson provides OAO members. And I would highly suggest that before you provide any information, you give us a call, because it is really important that the college does what it's supposed to do correctly, and you ought to confirm that they have done so before you hand over documents. Again, I have no examples where they've mishandled that, and I'm not suggesting that they would, but it's nonetheless imperative that they have what's called an appointment of investigators before any information is provided. You've got confidentiality requirements, and they don't have unlimited access to things in your office. They have to follow process. They are expected to comply with the code strictly. The courts have said it must be strictly complied with, and so should they not be compliant in whatever occasion that may be that they are not compliant, which may never happen, they shouldn't be receiving the documents. They should be complying and making sure they have an appointment of investigators. Other things that they can do once an appointment of investigator is obtained is they can obtain a search warrant. So they won't need that for your office because there's other powers to go into a member's office. But if they want to get documents from other people's offices, in the rare occasion, they will obtain a search warrant. And so they can, yes, come and copy or remove a document or object that it examined. So I just want to give you that caveat that yes, they can take information, they can take records, but they have to have, there's certain preconditions before they can do that. There's also an important provision that the legislation was somewhat recently amended to include, because there was a question that went to court about whether a member is required to cooperate with an investigation. Statute was silent once upon a time several years ago, and but there was common law to suggest that yes, a member of a college does need to cooperate with an investigation. That is now embedded in the code. So the answer is you do have to cooperate with an investigation. Importantly, you can't also, no one, whether the investigation is about you or somebody else, shall obstruct an investigator or withhold, conceal, or destroy or anything relevant to the investigation. So if there is a knock at the door and the college wants, or you become aware of a college complaint, or the college comes to your office, it's imperative that you do nothing but maintain all your records and do not make any changes to your records, no notations, even if it's to help remind yourself of some other, of something you want to remind yourself of. Your records must stay undoctored. They have to say pristine, or it will be deemed to be a obstruction of an investigation. So I do want to caution you on that. Make notes of your memory on a separate piece of paper somewhere else. Do not change your records.
So what is the process for investigating a complaint? Well, it's set out specifically in section 25 of the code, and I'll talk about it briefly to set it out for you. Within 14 days of the college receiving a complaint, the member will be given a notice of the complaint. This generally means being provided with a copy of the complaint itself. So if a patient, for example, sends an email or a letter to the college complaining about you, you will be provided with a copy of that email or letter directly, and along with a cover letter from the college. The member has 30 days to make written submissions in response to the complaint. We recommend that you contact your insurer to advise them as soon as you receive a complaint, and they'll connect you with legal counsel who can assist in preparing your response. Often if we're retained, and Lisa touched on this earlier, if we're retained towards the end of that 30-day period, say we get the call the day before your response is due, we'll seek an extension so that we have enough time to assist in preparing a response. And I've never encountered a situation where such an extension wasn't granted by the college.
But don't do that. Call us.
Don't do that. Call us soon.
Call your insurer and call us immediately.
Yeah.
Because it's never good to wait to the last minute.
But we do have workarounds if you do. And generally, the college will request that along with your written response, you provide the original patient record if there's a patient at issue, as well as copies of any financial records, any correspondence, any other documents that might be relevant to the complaint. They'll set out what they want in the cover letter. Once your response is provided to the college, they will provide a copy of it to the complainant. The complainant has an opportunity to provide further written comments, which you will get a copy of, and then the member provides the final written response overwhelmingly. The college can request further information from other practitioners or other persons if they feel that it's relevant. This often arises, for example, where a patient alleges a misdiagnosis or an improper prescription and later seeks a second opinion. The college may request, or we may request, and often do request, the records from the second practitioner. All of the information, the complaint, the various responses, medical, financial records, any other correspondence, any documents that are provided to the college are then provided to the ICRC, who can review it all, and they issue a written decision. An important concept with respect to college investigations and decisions is the legal concept of procedural fairness. Decisions of the college ICRC are considered administrative decisions, meaning they're not decisions made by a court, but they are nonetheless very impactful on the member to whom they relate. Administrative decisions and their investigations are the subject of a legal concept called procedural fairness. There's a large body of case law out there about this concept, and it states that the college owes a duty of procedural fairness to the members that it investigates. This is a somewhat omnibus legal concept because the content of the duty of fairness can change based on the facts of the specific case. With respect to college investigations and ICRC decisions, there's a number of things that a member can expect as part of their content of procedural fairness that arise from the case law, and it is fairly well entrenched. So the member can be expected to know the allegations made against them and to respond to them. That's why you get a copy of the complaint and why you get to issue a written response. The member can expect and is entitled to have the complaint decided by an impartial decision-making body, which is the ICRC, as well as to be provided reasons for the decision. Other aspects of procedural fairness may be triggered depending on the facts of the case, and additional rights may be triggered if the matter is referred to the discipline committee, but this concept certainly permeates all aspects of the college investigation process.
So the next polling question we have is, can the college restrict your certificate of registration in the middle of its investigation? So why don't you vote on that now? Okay, so 52, this is a real split. 52% of you said yes, and 48% of you said no. So that's pretty split down the middle. The answer is yes. And if we had done this presentation a couple of years ago, the answer would be no. So the legislation was changed a couple of years ago. There was, as many of you may recall, there was a sexual abuse task force that was looking at all regulated health professionals and the issue of sexual abuse. And one of the many criticisms that the sexual abuse task force made about the code was that at the time, the restrictions to one's practice on an interim basis could only be made after an investigation was complete and the matter had been referred to discipline. That was standard. And then, but the critics said, but sometimes investigations take a really long time, and there's risk to the public that exists while the investigation is taking place. That was the reality. That was the legislation. And in light of that, they changed the legislation. And the legislation now provides that at any time following receipt of a complaint or following the appointment of an investigator, the ICRC can make an interim order directing the registrar to suspend or impose terms, conditions, or limitations on a member's certificate of registration where it is of the opinion that the conduct of the member exposes or is likely to expose the member's patients to harm or injury. It's an extraordinary it's an extraordinary thing for the college to be able to put an interim restriction at that early stage. It's quite a power. It's really, the colleges recognize it's quite a power, and it's used in very extraordinary situations, often in the case where sexual abuse is alleged, particularly in cases where there's a number of people that's alleged to have been sexually abused by a member. Now, this isn't something that occurs a lot in your profession in terms of the allegations. So I'm not actually sure whether your college has ever done this. It's not limited to sexual abuse, but that's often where it has been used. It's important to know that if there is an interim restriction placed at any time before the discipline committee has heard the case, there is an obligation on the college to expedite things, because they recognize that it's a huge prejudice to the physician that's got either suspended or unable, or not the physician, the optometrist in your case, that's suspended or not, or has terms on their certificate of registration. So the answer is yes, it's an extraordinary power. It's used in very limited circumstances. That said, at any point in time, if they do feel that there's maybe a risk, they can ask the member to enter into an undertaking. And if anyone was to ask me at a college if that's something that they should seek to do before they impose this order, my answer would be yes, absolutely. Try to get an undertaking first, and that's certainly up to the member to decide whether they want to get an undertaking. But at that point, it's voluntary. There can be a voluntary restriction while they do their investigation. So I'm going to speak briefly about, we've talked a lot about what the Inquiries, Complaints, and Reports Committee is. It's effectively, it's a screening committee. They are the investigative committee. They themselves, the members, do not do the investigation. They happen to delegate that to, in your college's case, an outside group of investigators, people that are trained as investigators. The ICRC is meant to be and ought to be impartial. Investigations are meant to be a neutral fact-finding exercise. The complaint doesn't come, or the registrar doesn't have reasonable and probable grounds, and then it doesn't become the investigator's job to try to prove the complaint to be true or the concerns of the registrar to be true. To the contrary, it is intended to be a neutral investigation. And to the extent that it's not, there's remedies. But typically speaking, it will be. They will try to get all sides of the story and interview anybody that's relevant so that they can get all the facts that they need. And it will vary depending on the nature of the issue, who they interview, and if they even interview anybody. But at the end of the day, it's their job to get the facts, be neutral about it, and then take it to a 3-member panel consisting of optometrists and 1 public member. And they will ultimately make a disposition. And so what are the various dispositions that an ICRC can make? So at one end of the spectrum, they can do nothing. That's the goal. And what's considered nothing, but what they sometimes will do is not take action that's actionable, but they might sort of wag their finger in a letter with their reasons, give you a warning or give advice. That's considered a no further action decision. Okay. They, at the other end of the spectrum, can refer the matter to discipline, and that's something we hope does not happen, and it happens very, very infrequently. And in the middle, they can issue what's called a caution. So you're asked to come in and speak with members of the ICRC, where they caution you in person, or they can order what's called a specified continuing education and remediation program, or what's known as a SCRP. And so it's important to note that it used to be that cautions and SCRPs were not information that the public was privy to, but you may recall your college was part of a number of colleges who embarked upon a transparency project, and people were saying, all we know is people that have been referred to discipline. What about other, quote, records of, various health professionals? We don't know anything. And indeed, that wasn't information that was available to the public. It now is. So if there's a caution, or if there's a specified continuing education and remediation program, that is on the college's website, next to the particular health professional's name. So typically, the vast majority, you'll be comforted to know, the vast majority of dispositions are no further action. This is again from your college's from the annual report in 2018. And so they've separated no further action from advice or recommendation. You'll see that in this slide. There is, effectively there's no difference in the sense that yes, you're being advised or recommended to do something, but it's not an information that's public. At the end of the day, it comes in the decision, but it really is part of the no further action category. And they can also, so you'll also see here that where they've made their other dispositions, and you'll see that referrals to discipline are very few and far between. And so one other thing that they can do, it's not set out in statute, but they will sometimes do if they don't want to quite move to a SCRP, is do a remedial agreement, which consists of education, but there's a time limit and it will not stay on your record available to the public after it's complete. And so that's sort of the hive off that they've done once the SCRPs became public.
So we do have one last polling question, and that is whether the results of all investigations are available to the public. So we'll leave that poll
answered that with my mistake.
Open now, and if you were listening carefully, you'll know the answer. But I'm not able to see the results, so Lisa, perhaps you can read them out once the poll is closed. So let's take a look at what.
So we have 61% that said no, they're not available. No, not all the results of investigations are made public, and 39% yes, said yes.
So the answer is no. So the majority of you had that one correct, but it was a slightly tricky worded question in the sense that no, not all investigations are made public. Some of them are and some of them aren't. Where the ICRC determines to take no further action with respect to a complaint, that decision will not be made public, but the decision will remain in the college file of the member to which it relates. And this is relevant because the college is permitted to refer to and consider past decisions, even no further action decisions, if a member receives additional complaints in the future. But as Lisa mentioned, a caution, a SCRP, and a referral to a discipline hearing are all noted in the public registrar, which is available online. A question that often comes up is whether information from a college proceeding can be used in a civil lawsuit. For example, if a patient who makes a college complaint later sues a member for negligence, and Section 36(3) of the Regulated Health Professions Act is very clear that no record involved in a college proceeding, no report, no document, nothing, no thing prepared or statement given at a college proceeding, and no order or decision from a college proceeding is admissible in a civil lawsuit. However, I do note that the courts, while they've interpreted this ban very strictly, they've called it a quote unquote absolute ban, they have stated that it's okay for the court to be aware of the fact that a complaint was made without knowing any of the specifics or having access to any of the documentation.
I'm going to, in the interest of time, really fly through this. This is the hearing process. Effectively, it is a formal process. It's like a trial. The rules of evidence apply. There's a panel of optometrists and public members that sit and make the decision about whether the allegations are true, and if so, what penalties ought to be imposed. It's based on legal argument. After witnesses are called, documents are produced, and cross-examinations take place and arguments is made. It is open to the public. Importantly, the discipline committee members, none of whom are lawyers, I shouldn't say that, some public members may be lawyers, but they will have their own independent legal advice, a counsel that will sit at the hearing as well and give advice on legal issues. The college and the member are the parties to the proceedings. I think I've gone through this, that they make the determination of whether the allegations were proven, and then with more argument can order the penalty to be imposed. At the end of the day, there's a number of things that can be done, ranging at the most extreme to revocation. for extraordinary cases, some of which are mandatory. That really is sexual abuse, which I think I won't spend too much time on. They can suspend one certificate of registration, or they can impose terms, conditions, and limitations. So like, for example, to have a supervisor to take a course, they can ask you to come back and be reprimanded by them. They can have a fine be paid. They can order a fine be paid, and in cases of sexual abuse, can order that the member provide funding for therapy and counseling to the complainant or victim if there's a finding. They consider, the discipline committee, a variety of factors for penalty. These are commonly known penalty principles in lots of areas of law. The public protection is the main issue, and that argument is usually based on what will protect the public best. Maintain the reputation and integrity of the profession, and the public confidence in self-regulation is also a big one. Specific deterrence, so will this penalty stop the member from committing the same act? And the general deterrence of the profession, will our publication of this penalty stop everyone from committing this act? Where they can rehabilitate, they will. Usually when they think there's rehabilitation available, they will often do that well in advance of going to discipline. I'm not going to speak too much about this. It really doesn't come up very often, but certain frank acts of sexual abuse is considered a number of frank sexual acts, but it also includes, and this is where it's important, behavior or remarks of a sexual nature by the member towards the patient. So there does have to be a patient involved for it to be considered sexual abuse. And again, remarks or behavior in addition to frank sexual acts is sexual abuse. There are mandatory revocation for a number of, you can turn to the next slide, Lauren, if you would, for a number of frank sexual acts, which I don't need to go into, but there is no discretion at that point as to what the penalty would be.
I'm gonna as well move through this quickly in the interest of time, but the ICRC decision does have a number of routes of appeal. Decisions with respect to a complaint can be reviewed by a specialized administrative tribunal called the Health Professions Appeal and Review Board. And all other ICRC decisions that don't relate to complaints, as well as decisions from HPARB, can be judicially reviewed to the divisional court and could go up the various levels of court for further appeals from there, as you can see on the slide. HPARB, I'm not going to speak about in too much depth. It's a specialized tribunal. As you can see, it's not incredibly common for complaint decisions to be reviewed by HPARB. 5 of 89 were reviewed in 2018. The member and the complainant have a right to seek a review. So if the member feels the decision of the ICRC is too harsh, or if the complainant feels it was not effective enough, then either can seek the review. And HPARB has a very specific mandate. It can consider whether the college's investigation was adequate and whether the ICRC's decision was reasonable. Similarly, it has a limited number of remedies that it can order. It can either confirm the ICRC's decision, meaning the decision remains the same. It can refer it back to the ICRC to reconsider. It can make recommendations to the ICRC, or it can require the ICRC to do a specific number of things that are set out in the legislation. So I'm going to move on to what I think is most pertinent, which is risk management considerations, and particularly in light of COVID-19. I'm going to just very briefly touch on a discipline case that arose out of SARS and gives a bit of background and guidance to the obligations on a regulated health professional in a pandemic. The case that is on the screen is a College of Nurses case, but it's somewhat applicable, and it is applicable to all regulated health professionals. This involved a nurse who worked at 2 different hospitals. One of those hospitals had a SARS outbreak, and as a result, she was required to quarantine for 10 days, but she didn't. She showed up to work at the second hospital, and ultimately that issue went to the college's discipline committee, who did find that she engaged in acts of professional misconduct by failing to quarantine. So they found that she failed to maintain the standards of practice of the profession, and that she engaged in this omnibus clause that Lisa talked about, conduct that would be regarded as disgraceful, dishonorable, and unprofessional. In this case, her license was suspended for 12 weeks. She received an oral reprimand, and she was required to take courses on ethics and infectious diseases. So turning from SARS to COVID-19, what are some of the specific considerations with respect to managing the risk? First and foremost, make sure to keep up to date and to comply with all directions coming from your college and from the Ministry of Health in general regarding best practices. At this time, only urgent optometry care can be provided and appropriate personal protective equipment should be used. However, as noted in the case, the College of Nurses case that I just discussed, if you're required to quarantine, you must follow that direction, and you shouldn't be providing care at all if you're supposed to be quarantining. If you employ staff that are going to be working through this pandemic, you as an employer should provide them with access to appropriate personal protective equipment. So you do open yourself up to exposure if staff are working closely with patients and they don't have access to that PPE. I understand this can be a bit challenging, and there's not yet direction as to what specific personal protective equipment is required for non-urgent care, and PPE allocation continues to be focused on frontline staff. But your college has recently noted that the Ministry of Health is developing guidance about PPE allocation in your sector, so make sure to stay tuned for that. Similarly, your college notes that it is developing specific guidance regarding the return to the usual professional practice of optometry, so stay tuned for that as well. In our practice as legal counsel, we have not yet seen a patient complaint arising out of COVID-19, so we can't comment on that directly. It's certainly possible some may arise, but for now, it's a bit of a wait and see, and certainly keep your eyes to your college's policies, to directions from the Ministry of Health, and make sure you're complying with those. Generally speaking, we'll wrap up by kind of generally speaking, talking about the number of ways that you can reduce your risk of becoming the subject of a college investigation generally, and also putting yourself in a more defensible position if you do become the subject of a college investigation. The most important thing is to really know your professional obligations. As we've discussed, these come from a number of sources: the Optometry Act, the Regulated Health Professions Act, their various regulations, your optometric practice reference, college policies, and the overall standard of care of your profession, which comes from experience and from articles and other conversations with your colleagues, and it's something that you want to stay up to date on. So knowing what amounts to professional misconduct, knowing what amounts to appropriate care is utmost importance, so you can ensure that your practices are appropriate. Another really important thing is to always practice detailed charting, particularly if you have an interaction with a patient that's out of the ordinary. We recommend taking the time to chart what happened in the name of the patient record. Think about your charting by thinking that if it wasn't charted, it didn't happen. This is not, of course, technically true from a legal sense, but it's are questioned at a later date. You can understand what care you provided and why, and you can corroborate your actions through the contemporaneous patient record. We also recommend developing uniform clinic policies with respect to patient care and just interactions with patients, so that you can ensure quality and consistency. For billing issues especially, including fees that might be charged for missed appointments, copies of records, you may want to display those visibly so that patients aren't taken by surprise and become upset about a specific fee if it's part of a clinic policy. Regularly train your staff with respect to your policies and your expectations. As Lisa already touched on, as the regulated professional, you're responsible for your staff's conduct. And as we noted, a lot of complaints arise from communications issues. So you want to ensure that there's consistent messaging. Try to take all steps to clarify information, make sure everyone's on the same page so that it's not misunderstood, and also contemporaneously record information that's given so that there's a record of it. We have touched on this, but if you receive a patient complaint, advise your insurer right away so that they can ensure that you receive coverage if you want to retain legal counsel. And of course, finally, when in doubt, do seek advice from legal counsel. You have access to us through your association's agreement with our on-call program.
So I'll now share the questions you have submitted. The first question is kind of a two-parter. Should we contact Miller-Thomson as soon as we receive a complaint from the college? And if yes, does our professional liability insurance from HUB cover these consultations?
So I'll try to answer that. the answer is yes, you should contact legal, but you should contact Hub at the same time. I mean, it doesn't really matter which call you make first. What Hub, by and large, will get back to you quite quickly with an answer as to whether you have coverage. Where there is a delay, and you need to respond to the college, one of two things can happen. One is that you retain counsel independent of your insurer, whether it's us or somebody else, if you feel the need. The other is that you, I mean, I guess I would urge you just to really work with getting an answer as soon as possible. You could hold off, and then once the lawyer is retained, assuming you have coverage, then if an extension is needed, as Lauren said, invariably we will get an extension, or somebody who acts for you will get an extension. But what will be covered is the on-call program. Is something you can access at any point in time. The thing is that typically responding to a complaint, not typically, always responding to a complaint is more than the on-call program would provide. So you would ultimately need to retain a lawyer, because it's quite a lengthy process to do that, and it's not what the on-call program is used for. But you can certainly make that first call, and it would be covered by the on-call program, and we can advise you as to the next steps. But effectively, call Hub right away.
Good, thank you. Next question, how long do decisions stay in the file?
Forever. They don't go away. They're in your file. The colleges don't shred information. I mean, at some point they're stale dated in terms of their utility. If you get another college, so colleges use decisions as they're mandated to. There's some case law about this that came out some time ago where colleges weren't looking at history, and they said that's not sufficient. You need to look at the history. So any complaint that's in your file stays in your file really forever. And the college will, if you have a complaint and then you're subject to a second complaint or a third, or any other complaint, the college will say you have the right to comment on the history if you wish. And in doing so, you can either differentiate the previous complaint, or attempt to say why it's different, or or you don't have to comment at all on the history. So they will in fact consider the history, though. I mean, even if they have a number of no action decisions, but they're constantly being bombarded with complaints about professionalism, for example, at some point they're going to take some action where they may not have at the first complaint. So they can't reopen old complaints, but they can use the number of complaints or the nature of even one single complaint if it's relevant. It may not always be relevant.
Right. Thank you. And that kind of answers the next question. The next one was, if you have a previous complaint on the file, will it work against you if you receive a future complaint? And does the college try to find a pattern? I think you've somewhat answered that they might look at that.
I mean, I think that it only works. Like, unfortunately, someone's patient population may give rise to complaints more than others for various reasons. Like, you could be extremely just an unlucky person to get a number of complaints, and it doesn't mean because you have one in your file that you've done anything wrong. But they will, as I said before, nonetheless look to see whether there is a pattern. They don't try to find a pattern, but if there is one, that they'll maybe make their disposition based on the fact that they've deemed a pattern to exist.
Mm-hmm. Thank you. And one last question, are the statistics from the college available online?
They are available online. You can go to your college's website, or you can even Google their annual report. The statistics are in what's called the annual report. As I believe I noted, they don't have 2019 out yet, but you can look at 2017 and 2018.
Perfect.
I happen to have found 2017 on the OAO, sorry, not the OAO, on the college's website. 2018 required an actual Google, so I didn't see it on their website, but they're available to you.
Great, thank you so much. I'm conscious of the time, so at this time I'd like to thank Lauren and Lisa for this insightful presentation. And I'd like to thank Miller-Thomson for partnering with OAO for tonight's webinar. The webinar will be posted on the OAO website within the next few weeks. Please complete our survey as you log off. Thank you for joining us. Good night.